Good morning, everyone, and welcome to Butzel Long's webinar, An Employer's Guide to the New Families First Coronavirus Response Act's Paid Leave and Expanded FMLA Requirements. During this morning's presentation, please feel free to submit questions to our presenters using the GoToWebinar question panel. Our presenters will answer as many questions as they can at the end of the webinar, time permitting. Also, a copy of the presentation will be made available this afternoon on the Butzel.com webinar event page. So with that housekeeping out of the way, I would like to introduce Butzel Long shareholders, Brett Miller and Brett Rendero. Brett Miller.
Thanks, Jonathan. As mentioned, we are going to be talking about a very confusing new law. And no, we did not put two Bretts on the panel just to add to the confusion. We're hoping to clarify a few things today by going through some hot topics and questions that we've been receiving on these new laws. The Family First Coronavirus Response Act, broken down into sort of two main components we'll be discussing: the expanded family medical leave portion and a paid sick leave act that has come into effect. Both of these are separate laws that will apply to many employers. We'll talk about who's covered and who's exempted from these laws. We'll talk about which of your employees, for those of you who fall under these new laws, will be covered. There's going to be certain obligations and calculation of benefits. We'll go through that. Penalties and other considerations, including a DOL issued 30-day non-compliance period, but we'll be noting that there are also private possible rights of action. So we'll talk about those penalties and considerations. We'll go into how these two laws work together, and then we're also going to talk about some open questions. This is a extremely fast-moving topic. Just yesterday, the Department of Labor issued its first guidance and documents for employers on its website. If you go to the departmentoflabor.gov, you can see a frequently asked questions section and some guidance for employers that sort of clarifies some of this, but leaves open some questions such as whether intermittent leave is available under these new laws. We'll talk a little bit about the tax credits and how this paid leave is supposed to be reimbursed to employers, and then a little bit about how this works with unemployment for some companies who've already had to lay off or are worried about reducing the workforce. And again, hot topic, because within that, just last night or early this morning, a deal was supposedly reached on a stimulus bill that could provide up to 4 months of pay for unemployed workers that might cover a broader swath than what your typical Michigan unemployment. So again, this is a changing. We'll give you caution that everything we tell you could change by the hour or day, but we're going to go through what we know and what we don't know as of now. So the Family First Coronavirus Response Act, again, this is the broad category of the law that was passed that talks about the tax credits and includes these two laws we'll be talking about, the expanded FMLA and the paid leave. One of the first real hot topic or breaking news items, originally this law was going to go into effect April 2nd. The statute said no later than 15 days after it was passed, which put us on trajectory for April 2nd. In the guidance the Department of Labor issued yesterday, it is now an effective date of April 1st. So that is something that a lot of people were asking about. When do we have to worry about this law? When does it go into effect? April 1 is now the date. So again, we'll be talking about the sort of two main leave components, the FMLA expansion and the emergency paid sick leave. So again, this doesn't apply to everybody. There's going to be some employers who are covered, some who are not. So again, breaking this down into two laws we're talking about. On the slide, we have the FMLA expansion piece and the Emergency Paid Sick Leave Act. So for FMLA expansion, we're talking about companies with fewer than 500 employees, public agencies are covered under this law. And this can be confusing because it also has small businesses under 50 employees are covered by the FMLA expansion. So while the 50-75 rule that people are familiar with, the normal FMLA, not the expanded new law, but the normal FMLA that everyone's used to dealing with, only applies to employers who have 50 or more employees within a 75-mile radius. That rule is still true as to normal FMLA, but for this expanded FMLA, it applies to those with under 50 employees, unless they're exempted by the Department of Labor. And in the new guidance the Department of Labor has issued, the first thing they say is don't send us anything asking if you're exempt. I guess they've maybe been getting a few comments on this. But what the Department of Labor has said right now is if you believe you're under 50 and this new law would really jeopardize your ability to even field a workforce, you can document the reasons you believe you're exempt, and new regulations when they roll out in the next, hopefully soon, will address this. So that puts companies in a pretty, legally dubious position where they have to sort of self-designate their own exemption and then hope they don't get sued for it later. But we should have more clarification on that when the regulations come out. Healthcare providers, we have a lot of questions about this. There are special rules for healthcare providers and emergency responders. This also is still unclear because the Family Medical Leave Act definition of a healthcare provider is pretty narrow, talking about physicians who are exempt from the taking FMLA or nurse practitioners. It doesn't necessarily cover all the caregivers who are working very hard right now. So we're waiting for some more clarification from the government on that as well. But that's for your FMLA expansion. Your emergency paid sick leave, again, fewer than 500 employees for the private sector. Public agencies are covered. There's again some potential small business exceptions that the Department of Labor doesn't want to hear about. And the regulations will, again, hopefully cover both FMLA and emergency paid sick leave in terms of who can opt out of this law. But for right now, we're thinking it's going to be pretty broad, interpretation for employees to take leave and have pay. So another kind of new issue, we were waiting for guidance from the DOL as of yesterday on how to count employees. In the frequently asked questions document that the Department of Labor has put out, they did provide some guidance for expanded FMLA. They will follow the integrated employer test that is currently used within the FMLA. So, in other words, if you're trying to figure out if you're over that 500 employee threshold, and some companies have operations in different states or different subsidiaries, and you're trying to figure out who would be covered, you're looking at factors of common management, interrelation of business operations, common ownership, some very nuanced analysis that you should certainly talk to your attorney about if you're trying to figure out the definition. In the paid sick leave, also we're looking at a sort of joint employer test. So if you take the position for any other law that your company is not a joint employer with a sister company or some related company, you're probably going to be looking at maintaining that same analysis. Some companies have asked, well, can I just aggregate all 500 of my dispersed businesses? If I have 500 employees across the country in different businesses and they're not joint employee, we don't have them as considered joint companies now, but can I count them together for the purposes of this law? It looks like probably not. So there's more coming in the regulations, but the Department of Labor has issued some guidance on this now. And again, if you are a covered employer, you still have to look at which of your employees are covered. So for the Family Medical Leave Act expansion, employees must be working at least 30 days. The Department of Labor's guidance yesterday says that means they were on payroll last month. As of March 2nd, if you had these employees on payroll, so like a new hire but was on payroll as of March 2nd, they qualify for the FMLA expansion. Some of you may be familiar with the normal Family Medical Leave Act, what I call the usual FMLA, where someone has to work for 12 months and meet a certain hour threshold. That is not true for the expansion. They just have to be on your payroll in the last month. They also have to be, of course, be unable to work or telework. And as Brett Rendero will talk about in a moment, There's some specific rules. They have to be caring for a minor child, really related to the COVID-19 school closures, or declared health emergency. So that's sort of an encapsulating employee coverage on the expanded FMLA. You have a broader coverage on the Emergency Paid Sick Leave Act. Okay, this law, which we'll talk in more detail about in a minute, covers you, all employees who are working. Again, they have to be unable to work, but the categories that qualify these employees for coverage are very broad. Subject to a quarantine from the government, or a isolation order. So there's a debate about what that means, but theoretically, unless you're in a critical infrastructure or working for an essential employer under Governor Whitmer's executive order, if your business has been shut down under that order, there's an argument that these employees would qualify automatically under the Emergency Paid Sick Leave Act for 80 hours of paid leave. There's also, a broad interpretation of this. If they're covered, if they're displaying symptoms of COVID-19 and seeking a diagnosis, which could be anybody if they claim that they have a cough or a sore throat. And there's also other broad categories you can see listed here. So that's for the emergency paid sick leave. Again, broader than the FMLA, with more coverage, more employees who are going to fall under this umbrella. Then there's certainly more details on the FMLA expansion. And Brett, what do you think? What are you seeing on employees for expanded FMLA?
Sure, and good morning, everyone. Glad you're all here. Let's talk about the FMLA expansion under this new law. First, let's keep in mind that we still have the original FMLA in place. And you'll recall that covers situations where an employee needs leave because of birth of a child, an adoption, maybe because the employee has a serious health condition, or the employee is caring for a spouse or child or parent who has a serious health condition. And then, of course, the fifth basis for leave under the original FMLA relates to employees who require leave because of active duty military obligations. This law adds a sixth basis for leave under the FMLA on a temporary basis. It's again, as Brett Miller said, this will begin April 1st of this year, and it expires December 31 of this year. You're going to hear a lot about paid leave under the FMLA, and what's important to keep in mind is that the paid leave provisions only relate to the new form of leave under the FMLA. It does not apply to the original 5 bases for leave. Again, that's birth of a child, adoption, serious medical or health condition for the employee or certain family members, military leave. The paid leave does not apply to any of that. It only applies to this new 6th reason for leave under the FMLA. For this new reason for leave, there's a partially paid and a partially unpaid leave granted to employees who are eligible to take the leave. The first 10 days of the leave are unpaid. However, the employee during the term of this leave may use any accrued paid time off that they may have. They can use any paid sick leave, whatever benefits that you have in place for your employees. They can use that, but you cannot require them to use it. And as we'll get to, and Brett Miller will cover in just a few minutes on the Emergency Paid Sick Leave Act, employees may use that act if they qualify to cover or provide them with paid leave for the first 10 days of their unpaid leave under the FMLA. So again, the first 10 days are unpaid. For the paid leave portion, once the employees had 10 days of the unpaid FMLA leave, they can then convert to 10 weeks of paid leave. The 10 weeks of paid leave are paid at 2/3 of the employee's regular rate of pay. It can't be more than $200 a day, and over the term of the leave, it can't be more than $10,000 total for the leave taken under the FMLA. Now, again, I want to highlight here, these caps, $200 a day and $10,000 in the aggregate, are applicable to the leave taken under the FMLA. There's a separate leave that's available under the new law for the Emergency Paid Sick Leave Act. These caps do not apply to the caps that apply to the Emergency Paid Sick Leave Act. Again, we have to keep these things separate because that's how the law is written. How do you calculate the pay that's due to employees where they have a varying schedule? What you're required to do under the new law is to take the average number of hours the employee was scheduled per day, looking back over the 6 months prior to the leave. So you're just going to take again, look at the hours with a 6-month look back and average those hours. For those employees who did not work in the past 6 months or only worked a portion of the last 6 months, maybe they only worked 30 days because that's all an employee is required to do to potentially be eligible for these benefits. Then you look at what was the reasonable expectation for the hours the employee would have worked at the time that they were hired. So this is a gray area. It's ambiguous, and employers are going to have to use their best judgment here, keeping in mind that the concept or the intent behind the act is to provide employees with the pay that they would have otherwise received if they had been able to work during this time period. If you have questions on that, of course, give us a call. We can help you walk through it. I'm going to add here, this is just something that came out last night, so it's not reflected on our slide, but the Department of Labor added a question and answer fact sheet to their website. One of the questions on that fact sheet deals with what about employees who worked overtime in the past 6 months? Do I have to include overtime, the overtime hours worked when I'm calculating how much I should pay them or for how many hours? And the answer to that question is for the number of days, not hours, under the FMLA, you pay for the days, not the hours. That's going to be a different answer when Brett Miller talks about that, about the Emergency Paid Sick Leave Act, where that's based on number of hours worked. Again, under the FMLA and this benefit, this is based on the number of days worked. So don't get confused under the expanded FMLA about hours worked versus days worked. The FMLA will focus on the number of days worked. All right, let's go to an example here. This example is under the FMLA and deals with an employee who's an hourly medical assistant. In this example, the hourly employee's 12-year-old child's school was closed down, like all schools were closed down here in the state of Michigan by Governor Whitmer on March 16th. The employee is permitted to work under a shelter-in-place order. In other words, that means that the employee either can work from home, or the employee is an employee of an enterprise that's a critical infrastructure, which is an exception to the shelter-in-place order. So work is available to this employee. The employee earns $18 an hour and works 8 hours a day, 40 hours a week. This employee is unable to work at home in this example. And the employee in this example is also unable to work at all because the employee needs to care for his or her child who's out of school. So therefore, this employee, assuming the employer qualifies under the Emergency FMLA Expansion Act, this employee is entitled to leave because he or she is unable to work either at home or at the workplace due to a need to care for his or her minor child who's out of school due to the public health emergency. In this case, the employee has a waiting period, really two waiting periods. Number one, between now and the new effective date of the Act, April 1, the employee is not covered by the FMLA Expansion Act. Starting April 1, the employee is covered by the FMLA Expansion Act. So between April 1st and April 11th, the employee can have unpaid leave under the new FMLA Act But during this time, the employee can use PTO if they have it. The employee can use perhaps emergency paid sick leave, which again, Brett Miller will cover next. But you can't require the employee to use that leave. That's their choice. So they can take it unpaid if they want it unpaid, and if they have another form of paid leave, they can take that, but again, it's the employee's choice. Starting on April 12th, in this example, the employer must pay the employee $96 per workday. If the child's school remains closed to the end of the school year, but childcare also remains closed, the employer must pay the full 10 weeks, so that would equal $4,800 as a total benefit to the employee under the Family Medical Leave Act expansion. Okay, let's take another example. In this example, we're talking about an occupational therapist who's on salary. Similar facts, the employee's 12-year-old child's school is closed down by Governor Whitmer. It's been closed down since March 16th. The employee earns $80,000 a year. That breaks down for the math, $38.46 an hour for a 40-hour week. The employee is still allowed to work under the shelter-in-place order. The employee cannot work from home. In this case, again, the employee says that he or she is unable to work because of a need to care for his or her minor child whose school's closed because of the public health emergency. Once again, between now and April 1, the FMLA does not apply. Starting April 1st through April 11th, the employee may take an unpaid leave to care for the minor child. And once again, they can use any paid time off available through your policies, or possibly they could take paid time off through the Emergency Paid Sick Leave Act, or even possibly under the Michigan Paid Medical Leave Act. Starting on April 12th, the employer will have to pay the employee $200 a workday. In this example, the employee earns more than $200, well over $200 a workday, but they're hitting the cap here on a daily basis. So they'll just receive the $200 pay per day. The school's closed to the end of the year. There's no other child care option, so this employee remains unable to work for the total 12 weeks of leave. So they'll receive pay for full 10 weeks for a total of $10,000. Again, they're hitting the cap on pay in this example. Once again, just last night when the Department of Labor issued its guidance, it's really, there's two fact sheets and a question and answer sheet. But in those fact sheets, the Department of Labor added a term that doesn't appear in the statute. So the statute says that to be entitled to these benefits, an employee must be unable to work or telework due to a need to care for a minor child whose school is closed or the caregiver is unavailable due to the public health emergency. The Department of Labor added the phrase to that has to be a bona fide need. So in other words, the employee has to have a real need to care for their children under these circumstances. We've fielded many questions over the past week or so about, can I encourage my employees to use this benefit so that we take them off our payroll and push that cost or transfer that cost to the government who's funding this leave under these circumstances. And our answer to that is it has to be a bona fide need from the employee. The employee has to be genuinely unable to work or telework due to the need to care for their minor child who's out of school or can't go to their care provider. Let's go back here. There are other obligations under the expanded FMLA. One is a job restoration provision. Employers must return the employee to the same position generally if the position is still exists at the time the employee returns. There's an exception for employers with less than 25 employees. If the position no longer exists or their operating conditions have changed because of the public health emergency, then the employer does not have to return or restore the employee's employment, but you have to make reasonable efforts to restore the employee to a reasonably equivalent position to the extent that's possible. Also, employers must make reasonable efforts to restore employees to their position. Again, this applies to all employers. If you're unable to return your employee to a position, then there's a contact period. The contact period means that for 1 year, beginning, that's the 1 year period triggered from the date of the qualifying need concludes. So if the employees finish their leave, that triggers a 1 year contact period. So basically, it's almost like, think of it as a recall. If during that 1 year contact period, a position becomes available, you must reach out to that employee and make an offer to them to return to work. And of course, last bullet point here, under the expanded FMLA, employers must continue to provide healthcare benefits to the employees who elect to take this leave. All right, and with this, I've alluded to the fact that Brett Miller will talk about the Emergency Paid Sick Leave Act, and Brett, why don't you take it from there?
The expanded FMLA, where we were talking about a 10-day sort of unpaid period. Obligations under your Emergency Paid Sick Leave Act are immediate, starting April 1st. And we get a lot of questions from clients, and I've seen a couple already pop up during this webinar. Well, what do we do if we are already paying people PTO? Can't we just kind of dock this new leave entitlement from the PTO we've already given them, or from their current PTO? And the answer is so far no. Whatever you've done this month, before the April 1st effective date, if you've given people paid time off, vacation, once April 1st hits, this is a new entitlement that the employees, if they're eligible employees and you're an eligible employer, they get. So you can't then try to say, but we gave you 2 weeks last month. It's going to be a new entitlement, no waiting period, pay immediately. Again, they're going to have to actually qualify for the new emergency paid sick leave. And as I mentioned at the outset, this is a very broad coverage under the statute. So the employee it has to either be subject to a federal, state, local quarantine or quote unquote isolation order. There's a bit of a debate about what isolation order means, but the consensus seems to be that in Michigan right now, if you are employed, off work because your company is subject to the executive order and you are not an essential critical worker, you are under an isolation order. So, as we mentioned, that covers the recent shelter in place unless exempt. That, provides some sort of instant qualification. There's an open question on really what happens April 1st for employees who've already been laid off or quote unquote are not on the payroll at that date. That has not been addressed by the government. If they're no longer an employee, what employment benefits do they get on April 1st? We're kind of waiting for those regulations to see, but it's a huge question because a lot of companies have had to furlough or reduce workforce already this month before this law goes into effect. Another qualification would be, the employee has to be advised by healthcare providers self-quarantine due to reasons related to this. Again, we're talking about some pretty broad categories here. Employers experiencing symptoms and seeking a medical diagnosis. We note, yeah, okay, you can ask for a doctor's note. The CDC is saying don't ask for doctor's notes right now. The EEOC has parroted that guidance because it could overwhelm the healthcare system. And as a practical matter, it's going to take probably weeks for someone to get a doctor's note saying they're quote unquote experiencing symptoms of COVID-19. So we're telling employers to just prepare that, particularly under bullet point number 3, this is such a broad rule that you almost have to assume that your entire workforce is going to be, unless otherwise, exempt is going to fall under this if they want to. So one of the other questions we're seeing as well, when we look at this and the other qualifications, do we have to give this leave to everyone now? You can see the other qualifications that fall under this in terms of caring for others. And really, as of today, there's no duty to provide emergency paid sick leave under any of these 6 qualifications we've listed yet. So really, this goes into effect April 1st. That means on April 1st, you begin to apply this rule. A lot of people are saying, well, what if can't we just apply it now? Can't we start deducting from this now? Really, because the law is not in effect, that's not a good idea, and you would end up having to provide additional leave under the way the regulation, the guidance and the statute. As of April 1st, you'd have to just provide that extra leave time anyway. So again, there's these 6 categories, very broad, that would provide paid leave. So the amount of paid leave then becomes the issue. Okay, so for full-time employees, you get 80 hours of paid sick leave, paid sick time. And as Brett Rendero indicated, there's kind of different rules under the expanded FMLA for this. And the guidance that came out yesterday from the Department of Labor addressed some examples of how these 80 hours could work. And it gave an example of employees who perhaps work 50 hours one week and 30 hours the next week, and they get a total of 80 hours of paid time. But for those employers who sometimes have these staggered work weeks where people are working overtime one week or less the next, the Department of Labor says, okay, you've got to give them 50 hours of paid leave at their regular rate for that first week, and then 30 hours the next week. Of course, regular rate is then defined by figuring out what that employee normally earns in a 50-hour period, divided by that 50 hours, and you get their base rate. That's what employees would normally use to calculate an overtime premium. You don't have to pay overtime premium, but you have to figure out that regular rate and then pay the employees for that time. So again, we're already seeing with the guidance nuances and complications in how this is going to be rolled out and just determining what hours are going to be counted. But the takeaway here is it's a cap of 80 hours of paid sick time. The calculations also get a little more confusing when you're talking about part-time. Paid leave for number of hours the employee works on average over a 2-week period is what we're looking at. So the government is saying that you really want to average out a part-time employee's hours so that you can figure out if they normally work a 30-hour work week, they get that's the paid leave provision. Contingent, variable, and healthcare, sometimes called PRN, we see some different rules. So the Department of Labor says look back over 6 months or the expected average schedule. So if they haven't been working 6 months and you can't average out someone who's a variable hour worker who might go 10 hours one week, 25, 5 hours, if you can't average it out over 6 months, then you look at the expected schedule that they're supposed to work. So that's sort of something for like a lot of healthcare or people who really just can't set a number of hours. Look at that. For leave, having to do with employee self-care. So really kind of some of the first criteria we were looking at under this paid leave. they have to, they're sick because of COVID-19. They really have to care for themselves. The paid leave counts at 100% of the regular rate of pay, subject to a cap, which is $511 per day, and it gives you a total of about $5,100 total cap. So that's sort of the self-care provision. Now, to add some more confusion then, so if they qualify for emergency paid leave under one of these other provisions that we talked about relating to care for another person, or a sort of vague, we don't know yet, but some reason specified by the government, then the pay is at 2/3 of the regular rate of pay, capped at $200 per day or $2,000 total. So again, there's, even within all of the figuring out the hours, the regular rate of pay, you have to then look at why the employee is taking leave and determine if it's going to be the 100% pay subject to the cap or the 2/3. And again, it really, broadly speaking, relates to the what kind of care they need, self-care or care for another. So again, this can be confusing. The Department of Labor has issued this this question sheet that somewhat provides clarity, but we won't really know a lot of details until the regulations come out. So other considerations for emergency paid sick leave. So where, there's a lot of questions on this, on how this actually goes into play. So one is that employers can't just require someone to go find a replacement employee if they want to take leave. This is supposed to be an entitlement in this emergency situation. So the government's taking the position you can't just kind of require a replacement to cover a shift. On the same token, employers are prohibited from requiring an employee to use other paid leave before the employee uses the paid sick leave under the Act. So this goes back to kind of that question of, what do we do with our other PTO, our other paid time off, whether it's the Michigan Paid Medical Leave Act, vacation, sick time, whatever your normal policies are. Really, if the employees qualify, they are supposed to be able to elect and use this emergency paid sick leave without having penalties of loss of other pay. There may be some more clarification on the regulations, but that's how we read it now. And as a practical matter, I think if employers have to give this, it makes sense to have them use this emergency paid sick leave time, because as we'll talk about in a moment, it can be subsidized by the government. You're going to get tax credits, so it helps offset some of the cost of this, as opposed to your usual policies where you might offer somebody PTO, that you're not going to be reimbursed from the government for that PTO time. But under the emergency paid sick leave time, you will be able to seek that reimbursement in those tax credits. Of course, like any other leave entitlement, you can't discriminate against an employee who takes leave under the Act, files a complaint, institutes a proceeding, kind of the typical anti-discrimination, anti-retaliation rules that we see with other entitlement statutes. There is also a penalty for not providing sick leave under the Act, and it relates back, the statute kind of just points to the Fair Labor Standards Act penalties, which could include minimum wage, liquidated damages, attorney fees, possible injunctive relief. There are some caps subject to the amount of leave the person would be entitled to, but again, there are private rights of action within this. So, we mentioned at the outset that the Department of Labor has indicated that there's going to be a good faith compliance period where they want this new rule to be rolled out for 30 days. And whether there's a Department of Labor kind of grace period on this does not necessarily have anything to do with a private right of action. So we want to make sure clients understand that people can still sue, even if the Department of Labor is taking a different position. So it's something just to be aware of. Sometime today, the Department of Labor is supposed to come out with a model notice and a poster on the Emergency Paid Sick Leave and Emergency or Expanded Medical Leave Act. So once this poster comes out, you'd have to post it like you would in any other normal area. Given the crisis right now, with a lot of people teleworking, I don't know that just posting a poster in the break room where people congregate is the best. You might have to do it, but we also are talking about making sure you email the poster, get information out to employees who might be working remotely, so that you can make sure that you're meeting the Department of Labor guidelines on notice to your employees. In terms of how this works, in terms of people have scheduled shifts, they're calling in, an employer can require employees to follow reasonable notice procedures and to receive the sick time. Again, this is going to be construed pretty broadly, but there are some rules that people still have to, there can't be a no call, no show. There's still supposed to be some notice and some provisions to employers. So, the other aspect of this is when I'm seeing some questions on the webinar, how do these two laws really work together? Where do they intersect? And Brett, what do you think about the intersection of these two new laws?
There certainly is some interplay between the FMLA Expansion Act and the Emergency Paid Sick Leave Act. Let's take the example again of the employee who's unable to work because the child's school is closed. The Emergency Paid Sick Leave Act could pay for 2/3 or provide the employee with paid leave, which would be 2/3 of that employee's wages for the first 10 days that he or she is unable to work due to that school closure or daycare closure or the child care provider being unavailable. And it's limited to 80 hours, as we talked about earlier. But as the Emergency Paid Sick Leave Act can pay for the first 10 days of that leave, then the employee, for the same exact reasons, can then use the FMLA expansion to pay for the following 10 weeks of leave, again, still at 2/3 of the pay, limited to $200 a day and $10,000 max. The $200 a day and $10,000 maximum applies to the leave under the FMLA. The Emergency Paid Sick Leave Act is still capped at $200 a day, but it has the separate $2,000 maximum. So if you combine the two acts together for an employee who's on leave because he or she is unable to work or telework because of the schools being closed or childcare not being available, they could receive a total of $12,000. Again, $10,000 maximum under the FMLA Expansion Act and $2,000 under the Emergency Paid Sick Leave Act. Another very hotly debated issue amongst lawyers, and none of you will be thrilled to hear us say what we're about to say with respect to intermittent leave or reduced hour leave. So think of the employee who says, well, I can work. I can work on site, I can telework, but I can't work on Fridays because my care provider is no longer available, or it's my spouse who can care for my child Monday through Thursday, but not on Friday. So I'll work for you. I want to help you. I want to be a good employee, but I can't work on Fridays. I'd like to have an intermittent leave. Or a similar situation is someone who says, well, I can work, but I can't work past 4 o'clock because my spouse has to leave for work, and we're sharing childcare responsibilities. So I can work each day, but if I'm normally scheduled to work to 5:30, I have to get off at 4 each day. So I'll just take my FMLA and my Paid Sick Leave Act just for an hour and a half each workday. That way, again, I can still work, I can help you, but I have to take advantage of these acts and take this leave, but just for an hour and a half a day. The answer is we don't know if intermittent leave or reduced hour leave is available under either the expanded FMLA Act or under the Emergency Paid Sick Leave Act. Let's look at the FMLA first. Under the FMLA, I mentioned earlier, and most of you know, that there are 5 reasons why you can take leave: birth of a child, adoption, your spouse, child, or parent has a serious health condition, the employee has a serious health condition, or there's leave due to active duty military service. Those are the reasons for leave under the original FMLA. And the original FMLA tells us for each form of those 5 reasons for leave, which ones can be used on an intermittent or reduced hour basis and which ones can't. For example, for birth of a child, there's no intermittent or reduced hour leave available for birth of a child. Same thing for adoption. There's no intermittent or reduced hour leave available. But for the employee's serious health condition, an employee is caring for a spouse, child, or parent who has a serious health condition, or someone who's on an active duty or has active duty military obligations and is on a leave, those folks all get intermittent leave or reduced hour leave if they request it. So when Congress added the 6th new basis for leave, you're unable to work or telework because your child is out of school due to a public health emergency, Congress neglected to also tell us, so is that available for intermittent leave or not? Similarly, under the Emergency Paid Sick Leave Act, that's an entirely new law under federal law, and once again, it doesn't tell us whether or not it's available on an intermittent or reduced leave basis. Making matters even worse, when this law was initially proposed in the House of Representatives, it included provisions under both the new FMLA and under the Emergency Paid Sick Leave Act, which would tell us whether or not there was intermittent leave. But when Congress actually passed the law, they deleted those provisions. So leaving us all to guess how this is going to unfold. Now, we are still expecting more guidance from the Department of Labor, and there is an opportunity for us to provide feedback to the Department of Labor and saying, hey, you didn't tell us that this is available for intermittent leave or reduced hour leave. Employers need that guidance. And we hope to get that guidance in the coming days or weeks. But in the meantime, it looks like there's a very good chance that this law will start on April 1 without the benefit of that guidance. One last thing on this point is that the Department of Labor has announced that for the first 30 days that the act is effective, that it will not take enforcement actions against employers who are working in good faith to implement the requirements of the law. And instead, they're going to use that 30-day period for what they call compliance assistance. And so we really hope that during that compliance assistance phase, that employers will receive additional guidance from the Department of Labor as to whether or not intermittent or reduced hour leave is available. So next is tax credits. A lot of employers want to know, am I going to get reimbursed for the leave and the cost of this leave? And the answer is yes, so long as the leave actually qualifies under the emergency FMLA or under the Paid Sick Leave Act. There's going to be a payroll tax credit that will cover the cost of the wages for the leaves authorized by this act. If the amount of the credit exceeds your payroll taxes for the quarter, that excess amount is refundable. And what that means is when you withhold your tax withholdings from employees' payroll checks, that will be your primary source for paying for the leaves under this act. And if the amount of your withholding is not enough to pay for all of those wages, then you're able to essentially apply for a credit that is supposed to happen very quickly, where the government will actually push money into your trust account, so then you can withdraw it and pay the wages or reimburse yourself for paying those wages. There are 3 components to the credit. It's 100% of the wages that were paid under either of the acts, the FMLA or the Paid Sick Leave Act. But keep in mind, in order to get the credit, the leave has to meet the requirements of those 2 acts. If it doesn't, you will not be reimbursed for any of the wages that you paid for that leave. Employers will also be reimbursed for the hospital insurance tax, which is a component essentially of your Medicare withholding. And then health plan expenses are also eligible to be reimbursed but those are only the amounts that are actually incurred to maintain the group health plan attributable to the employee who's on leave. We've been receiving a lot of questions about how does these new federal laws relate to unemployment? And the simple answer is that they really don't work together. They're two separate concepts for the time being that may not remain the same as Congress continues to pass new laws to assist employees during this time of uncertainty. But for the time being, these don't really work together. Once someone is on unemployment, under the guidance that we presently have, those employees are no longer employees. They're either on layoff, they were furloughed, or they've been terminated, but they're former employees. That's how the law has traditionally regarded them. The benefits available under the expanded FMLA or under the Emergency Paid Sick Leave Act are for employees, people who are on your payroll. This, again, could change as we receive new guidance from the Department of Labor or as Congress passes new legislation that may alter this. But for the time being, the new laws don't really relate to unemployment. You're either an employee and you're eligible for these new forms of leave, or you're no longer an employee, in which case you would be eligible for, or may be eligible for, unemployment. We're going to transition to a question and answer period, and I'm going to return this to Brett Miller to have him lead us through that. But before I do, I want to remind or let you know, if you haven't heard already, that Oakland County, so for any employers who have operations in Oakland County and have employees reporting to work presently, there is an order that goes into effect at 12 noon today that has requirements with respect to questioning employees about their about whether they have a fever, a cough, shortness of breath, etc. Keep those things in mind. If you have questions about that order, give us a call. It's not really part of this presentation, but since it goes at 12 noon today, we wanted to remind you of that. And with that, Brett, why don't you take us with questions?
Sure thing. We're getting some questions that are some great questions, and some that we are seeing pretty commonly. You know, one question on we've been mentioning, Brett, a lot of the discussions in both of these laws about school closures, school age kids, and a question we got is there an age cutoff, or is there a certain, you know, is it elementary schools only? And the statute says elementary or secondary school, and I believe that's both you know, your elementary, middle school, and high school. Is that your understanding as well, Brett?
Yeah, anyone under the age of 18. So any children that are out of school who are under the age of 18 and the parent is unable to work or telework because they have to care for those children. I know some of you may chuckle with that, but that's what the law says. I will add that, again, with this new guidance, it says it has to be a bona fide need for leave. So it has to be genuine, but at this point, given what the law says and the idea of providing assistance to employees, if the child's under 18 and there's no care available or school's closed due to the public health emergency and the employee says they need time off, they're probably going to qualify for this leave.
We're getting some questions about that as well, and the bona fide leave. So what if there's a non-working spouse at home and the employee wants to take off under this provision to care for the child anyway? What do you recommend?
Well, it's a great question. And this new bona fide language literally came out within the past 15 hours. It came out late yesterday. So all of us are trying to digest what that means. In the absence of any further guidance from the Department of Labor on whether or what bona fide really means in this circumstance, you're going to have to take each case as it comes to you. I would caution you against saying, no, you have a spouse who doesn't work at home, so that spouse can take care of it. You go get to work. Be very careful about that. Take each of these circumstances as they come at you. Give us a call. We can help walk you through it. But in many cases, you're going to lean toward the employee gets the leave, you're going to grant it.
What about other family members? You know, FMLA, the old FMLA, has some very specific rules on, what family members qualify. Under this new rule, are there other than, the minor children we've talked about, are there siblings or other individuals who might fall under the care provisions?
Well, under the new FMLA provisions, it relates to the employee's minor child. And so it's going to be limited to, again, just the employee's minor child or children who are out of school because of this public health emergency. But that's different under the Emergency Paid Sick Leave Act. Under that act, it says that if the employee has to or cannot work because he or she needs to care for an individual who is subject to a quarantine or isolation order, or who's been advised by a health professional to quarantine due to concerns related to COVID-19. Again, it uses the word individual, and the word individual is not defined. So certainly it's broader than just the employee's children. It could be parents. It might even be someone who's unrelated to them if the person is actually providing care for an individual who falls within those categories. So depending on the law, which law it falls under will dictate whether or not it provides paid leave for that employee.
That's a great point, Brett. Well, a lot of our client questions focus on the expanded family medical leave. I think it's a more familiar law out there. The FMLA has been around since the 90s. And they forget about the expanded Paid Sick Leave Act that's coming into play. And there are different broader categories, as you mentioned, for who gets those 80 hours of pay. So it's something that, as employers are going through these analyses, got to have a checklist of expanded FMLA, expanded Paid Sick Leave Act, and kind of really consider those policies. We're getting a lot of questions too, and how that intersects with your short-term disability policy or your short-term disability insurance. We get questions, and we've had a couple in this webinar of, can I just foist people off kind of on short-term disability or have them apply to cover some of this PTO issue? And almost all short-term disability policies that I'm familiar with are going to require an exhaustion of any paid leave before the short-term disability policy kicks in. Is that your understanding as well?
Absolutely. And if anything you're considering with your short-term disability policy, review your policy. But I agree with Brett. That's going to be the case in almost every circumstance.
Okay. We're having a lot more questions about sort of things that have been going on and are currently going on in terms of this week before April 1st. Some questions businesses have had, COVID-19 scares and had to send people home. Other businesses are providing paid leave now, before the 1st. And we're kind of getting this question about whether whether any of this can be sort of deducted from these new entitlements that go into effect April 1st. And just to be clear, we had kind of gone over this a little bit earlier, but our position right now is that you cannot use what you're doing now, whether you're voluntarily paying people to, who are maybe off work, whether you're using PTO now, you cannot then try to recoup that or deduct it from these new entitlements after April 1st. And these are going to be new paid leave entitlements in addition to whatever you've done starting April 1st. And I mean, would you agree or have anything to add to that one, Brett?
Completely agree. And I would add, don't forget about Michigan's Paid Medical Leave Act, which went into effect last year. Last year. The past week has moved so quickly. That I forget how long ago the Paid Medical Leave Act has been in place in Michigan. But as Brett Miller just said, the benefits available under the new federal laws are available beginning April 1, and they are in addition to any paid time off or other leave benefits that an employee may have. Under Michigan's Paid Medical Leave Act, which is in place right now and does cover employees who need to be absent because of a public health emergency, including caring for children who are not in school because of a public health emergency. That law is in effect right now. But the Michigan law is different than the federal law in that the paid medical leave available under state law is not in addition to other benefits. In other words, all you have to do under the Paid Medical Leave Act in the state of Michigan for those employees who are subject to it and employers who are subject to it is provide up to 40 hours of paid time off. For example, if an employee had 40 hours of paid time off, they took a vacation in January for 40 hours, they exhausted their PTO bank, but now their children are out of school and they want to take paid medical leave under state law, you don't have to provide that. They've already exhausted their 40 hours of PTO. A similar example, very quickly, is what if the employee had 80 hours of paid time off and they took 40 hours of vacation in January, so they still have 40 hours in their leave bank. What about the Paid Medical Leave Act? Well, the Paid Medical Leave Act, again, only says the employees have to take, or you have to provide them with 40 hours of paid leave. So the act doesn't apply. On the other hand, the employee does have 40 hours available of PTO, and if it's available under your policy, you may otherwise have to provide or allow the employee to use that PTO as we lead up to April 1.
Okay, but we're getting a few other questions. We'll take a few extra minutes to go over here. And one is going back to the kind of confusion on the isolation order and our current stay-at-home executive order. And there is a lot of uncertainty in this area, Brett, but I think our best advice right now is that if your business is going to be shut down as of April 1st and you have current employees at that time, and you are affected by this isolation order or the stay-at-home order, that provision of the Emergency Paid Sick Leave Act would apply. If you are an essential business, if you're critical and you have employees who are working, they are not subject to the isolation order, quote unquote, because they are still able to work for a critical or essential business. So that specific provision of the Emergency Paid Sick Leave Act would not apply. And we're getting some questions also because the governor had issued, going along with that, a guidance saying, don't lay people off. Tell them it's a furlough or a temporary layoff for 120 days. And I want to clarify that this is not, in the reason it's set forth in that governor's guidance from Governor Whitmer is to allow employees to be eligible for some of these federal leave programs that are rolling out. And I think, Brett, that is not law. That was not an executive order. That was guidance from the governor just suggesting not to really rush out and reduce your workforce, lay people off, keep them on your payroll, keep them on the books, furlough them so that they are current employees, with the idea that the state of Michigan wanted to bridge employees to get to the April federal entitlements. Do you have any other thoughts on that, Brett?
No, I would just echo that that is guidance from the governor. And hey, from the state of Michigan standpoint, it makes sense because the state of Michigan provides the funds in most cases for the unemployment fund through employer contributions, of course. And if they can keep employees off of the Michigan unemployment fund and bridge them somehow to get to the federal or to be eligible for these new federal leaves, that would push the cost off to the federal government. So it's no surprise that the governor has urged employers to consider that, but certainly it's not law, it's not a requirement. Each of you have to determine what's in the best interest of your business and your employees.
I know we've gone a little bit over our time. Our contact information is up on the screen. So if anybody has questions, please reach out to whoever your usual employment attorney is. Reach out to one of the two Bretts on this webinar, or anybody at our firm in our labor employment group. We are happy to take additional questions. We'll be issuing guidance, and as soon as stuff is released by the Department of Labor, when we have regulations, check Butzel.com website. We will be posting client alerts and additional information as we have it. Right now, it's moving very fast, so we're trying to give the the best information for what is current. But again, please feel free to reach out with questions.
Thank you everyone for attending. As we're out of time, we apologize we weren't able to answer everyone's questions. Just a reminder, thank you, Brett and Brett. A copy of this presentation along with a recording will be available on the Butzel.com website later this afternoon. Thank you everyone for attending.